We're with David Shapiro. David is a criminal defense attorney in San Diego, California, and he's agreed to answer some online questions that were posted. With that said, David, let's go into the first questions. These are all about drug crimes, by the way. So the first question was from Ruben. Ruben says, I've been charged with drug possession for the first time. Cocaine, but it wasn't a lot. Can I avoid jail time?
Ruben, depending on your record, you probably will avoid jail time. If you don't have a record, you might be eligible for a diversion program where you would ultimately enter a plea to the charge if it can be proven against you. You put off sentencing 18 months, you stay out of trouble, you complete an outpatient drug treatment program, the plea gets withdrawn, the case ultimately gets dismissed. That's known as a PC 1000 program. Even if you have a pretty lengthy criminal history, you would technically be facing up to 1 year or 364 days in jail if convicted. How realistic jail time you get depends on the amount of drugs, your prior criminal history. But generally, for simple possession offenses, we're pretty successful, and most attorneys are pretty successful in trying to get you out of actual jail time. But nevertheless, you still want to make sure you leave no stone unturned in your defense, because there's a lot of different programs and different options and defenses you might have.
Okay, next question we had was from Janet. Janet says, how do the police decide what is possession and what is possession with intent to distribute?
Well, for up to the police, I think they charge everybody with possession with intent to distribute. They tend to overcharge or are a little cynical on what a user would use over the course of a day or a week. But it's ultimately going to be up to, on the front end, the police make the arrest. They may make their recommendation what they book people in jail on, but it's ultimately going to be up to the prosecutor if they decide to file charges, and if they decide to file charges as a simple possession or possession with intent to sell or distribute. Laws in California have changed dramatically in the last couple of years, not necessarily decriminalizing simple possession, but reducing simple possession of cocaine and heroin from felonies to misdemeanors, reducing simple possession of methamphetamine from a wobbler, a felony or a misdemeanor, to just a misdemeanor in almost all situations. What that has done, in one regard, that's a good thing, but on the flip side, it's increased the disparity in sentencing ranges between simple possession and possession for sale. If you're convicted of possession for sale, it's a non-reducible felony. That's a felony conviction that can never be reduced to a misdemeanor. It's also priorable and add 3 years onto any future possession for sales case. So the tendency sometimes is to overcharge these cases, meaning where they'll charge it as possession for sale, and it's become more difficult to actually work out a resolution for simple possession because the DA doesn't want to give up the felony. The DA doesn't want to give up the prior ability that the felony charges would carry. But if they're being unreasonable, if the facts don't support it, there's many things your attorney could do. They could take them out at a preliminary hearing. They could hire their own expert to sort of rebuff what the DA is saying, some investigation as to what your drug habits may be if you're using, and all those factors that go into it. And in all honesty, especially if you don't have a record and the DA wants you to plead to what you're charged with, you may not have incentive to resolve the case. It may be in your best interest to fight on, even if you don't have the greatest defense in the world. Only an experienced defense attorney, well-versed in the law, well-versed in practice, can be able to advise you on what's in your best interest in that regard.
Okay. Next question was from Marian. If an undercover officer tries to offer you drugs for sale and you haven't asked, is that entrapment?
Well, entrapment's an affirmative defense, and basically what that means is, first off, the undercover officer offers you drugs. I'm assuming you would have had to have accepted them and then ultimately gotten arrested. You hear that a lot. Well, isn't that entrapment in prostitution cases and drug cases? But as far as the drug cases go, generally what you would need to show for entrapment is that you weren't intended or inclined to do that, meaning to take possession of the drugs, but for, and only because of the insistence of the other person is how you came into possession. If you were inclined to do it just because the undercover came up to you, doesn't make it entrapment. If you were walking away and said, hey man, I'm good, leave me alone, and they kept pressuring you and kept pressuring you and kept pressuring you and kept pressuring you, maybe you have a borderline entrapment defense. But it's not as common, and certainly not nearly as successful as a defense as many would hope it would be.
Okay, next question was a very short one from Jay. Can anyone smoke marijuana now that it's legal?
Not anyone. If you're on probation and it's a condition of your probation not to smoke marijuana, you can't, irrespective of what the law is for people who aren't on probation. You need to modify your probation terms. There's certain offenses there's certain offenders or people with certain backgrounds where simple possession, which would be an infraction or low-end misdemeanor, Can still be prosecuted very seriously as misdemeanors or felonies, depending on your record. So not everyone, no.
Okay, the last question we have is from Melissa. In what ways is a drug-related DUI different from an alcohol-related DUI as far as the penalty?
Well, as far as penalty goes, they tend to be treated relatively the same. But as far as penalty goes, if you're convicted of a drug-related DUI, your license would be suspended for at least a year, even on the first time, and you would not be allowed to get a restricted license the way you would if it was an alcohol first-time DUI. That's one main difference. Another difference is it's a lot more difficult sometimes to prove those types of cases, the drug cases, because there is no hard and fast, line in the sand type of offense level where it's, hey, it's this many nanograms per milliliter or something, or this many whatever, of THC is good enough for a DUI. But the penalties increase sometimes if you are under the influence of a controlled substance and DUI because of that controlled substance, because then you could also be charged with being under the influence of a controlled substance in general under the health and safety code, which doesn't necessarily require proof that you operate in a motor vehicle. So a lot of times on DUIs with, drugs, we see the underlying misdemeanor of driving under the influence of a controlled substance, as well as just being under the influence of a controlled substance as well. So a lot of times it's actually a whole other misdemeanor charge that you need to defend against.
Excellent. Well, I hope that answers all your questions. If you have more, just post them in the comments section below. And David's agreed to get back to you in the answer. And thanks for answering the questions, David.
Yeah, sure. My pleasure. And again, I could always be reached at 619-295-3555. Thank you.